it goes quite far. But let's move on to the second argument of Memec, and they say that the dividends, the share of the profits received should be treated as a dividend, and then again you fall back into both Article 18A for the direct tax credit and Article 18B for the indirect tax credit. But then the judge says, well, let's look at what dividends mean, right? And Article 6 in this old treaty defined dividends, and it says paragraph 1 provides that dividends paid by a company to a resident in one of the territories to a resident of the other territory may also be taxed in the former territory, but not at a rate in excess of 15%. Yeah, and then paragraph 4 of Article 6 contains an important definition. It says the term dividends means, in the case of the Federal Republic, the term includes the income derived by a sleeping partner from his participation as such. So quite clearly, the treaty says, you know, the sleeping partner share is a dividend, but it says so for, if you look at the beginning of the definition, the term dividends as used in this article, right? And what the judge's point is, it only defines dividends for Article 6. It doesn't define dividends for Article 18. In Article 18, dividends are different, right? So the court then goes on to say, the question in the present case is whether the absence of a definition of dividends in Article 18 signifies that it is to be construed in that article as having the same meaning as Article 6.4, or as having a meaning indicated by Article 2.3, which is the normal 2.3 that we know from OECD Model Convention, which allows UK law to determine its meaning. Okay, and then we're back into national law. The fact that the definition is not included in Article 2 as a general definition supports the view that the draftsman did not intend for Article 6.4 definition to apply whenever dividends is found in a convention, because then if that was the case, they would have taken the 6.4 definition and put it into Article 2.3, right? Into Article 2, not 3. 3 is if there's no other definition, so it will be Article 2.2 or 2.1. That view is strengthened by the fact that Article 6.4 was substituted by the 70 Convention at the very same time that Article 18 was substituted. So they could have thought about this, right? Mr. Venable submitted, Mr. Henderson did not dispute that in 2 other articles of the Convention, references to dividends are to be construed as having the same meaning as Article 6.4, but that is because both those articles relate to tax withheld from a dividend, and so implicitly cross-refers to Article 6, so it's referring to withholding tax, not indirect taxes. By contrast, Article 18, 1, dividends only appear in connection with relief for German underlying tax. Relief from German withholding tax pursuant to Article 6.1 is afforded by Article 18.1a, not b, right? Whether or not the dividend, the payment is a dividend as understood in the UK. So basically, this does not help the taxpayer. And then the judge goes to national law, and we'll just go through it briefly. I don't know what article, what part 18 of the 1988 Act was, but Mr. Venables refers to 2 articles there. The first one is 790 paragraph 6, in which Mr. Venables argue that a right enforceable by a silent partner against the owner to receive a share of the profits and a payment of such share can properly be described as a dividend. But that's exactly what the silent partner got, right? And then the judge says, the judge does not beat about the bush. He says, in my judgment, this argument is hopeless for the reason just given, and that was referring to the Article 6 of the treaty, and then being thrown back in Article 2.3, which throws you back into UK law, and it doesn't require the definition given by the treaty. And because of the language of Article 790, paragraph 6 itself, referring as it does to a dividend paid by an overseas company to a UK company which controls not less than 10% of the voting power. And it clearly uses the word dividend, not silent partnership interest, right? And then there was also a section 800, and Mr. Venable submitted that if dividends were not of a class which fell within Article 18 of the treaty, relief was available under section 800. And I think he might also have implied, you know, that either 790 or 800 applies, but it can't be so that neither of them applies, right? So then the judge says dividends, he said, or the Mr. Venable said in Article 800, must be interpreted in accordance with the applicable convention. And then the judge responds and he says, Mr. Venables wisely did not press this argument, which again seems to me impossible. Section 800 has no application to the present case where no dividend was paid to PLC in respect of any class of shares held by it, but merely a share of GmbH's profits of in the silent partnership. So again, 800 is not applicable to silent partnership income. And then the judge concludes, for these reasons, I would reject all the contentions of the taxpayer. And then he still goes easy on Mr. Venables. He says, despite the well-sustained arguments of Mr. Venables, by which he demonstrated his great expertise in this field, I would dismiss this appeal. So therefore, Memec loses before this judge. There were 3 judges on the panel, and the second judge agreed with the first judge, and then Sir Christopher Staunton had a different opinion about the interpretation of Article 6.4. And then he starts by saying, as to point 1, I agree with Robert Walker J, and that was the judge from the previous court, not this court, that the word dividend in Article 18 should be given the same meaning as it is defined to have in Article 6.4. So he disagrees with the first judge in this court, right? In other words, it includes the income derived by a sleeping partner from his participation as such. I appreciate that Article 6.4 says, as used in this article, but Professor Klaus Vogel, famous international tax academic from Germany, cites the decision of the highest German court for the proposition that the word should bear the same meaning elsewhere in the treaty. And then the judge says, it seems to me very likely that continental courts generally, like the German court already mentioned, would reject the semantic restriction to the words as used in this article and would hold that the definition could be relied on elsewhere in the convention. In the interest of uniformity, I would do the same. And this sentence, in the interest of uniformity, brings up a lot of reference, right? Because one should then go and look at the case of Concentric Services BV, which is also discussed in elsewhere in this course, on the concept of common interpretation. Treaty partners should try, and the courts of treaty partners should try to interpret the treaty in a common way, right? Because I mean, the whole idea is that you make a treaty so you can do things in the same way, and then it's absurd if the courts go and do it in a different way. But it doesn't mean that one court binds another, right? And that is the issue here. And there's also, if you want to really go into common interpretation and how you cannot look at a UK treaty like you look at UK law, you should look at the Fothergill decision, which is also referred to elsewhere in this course. And that was the very beginning for UK law purposes of common interpretation, as I understood. So the judge concludes it is still necessary, even though you can say Article 18 dividends in the treaty are the same as 6.4, it is still necessary for Memec to rely on the Tax Act of 1988 if it is to get a credit for the taxes borne by the subsidiaries of Memec GmbH. For that purpose, PLC relies on Article 790 and 801. I don't know what 801 says, but each of those sections refer to dividends, and there is no definition of dividends in English domestic law, which would include distributions made by a body such as a German partnership. Article 6.4 of the Convention cannot, in my judgment, be treated as governing the taxes of 1988. It follows that the same second argument must likewise fail, and the appeal must be dismissed. And this is again very fine differentiation, right? Because the court doesn't say you apply the UK definition of dividends in Article 790 and 800. He just says that even if you use this treaty definition, those do not fit within the UK Act of 790 and 801, and you can't get a credit under national law for those, right? It's a bit of a, I think the judge contradicts himself a little here, because if he says that the Article 6.4 definition applies for dividends, and therefore the UK must give an indirect credit, one may wonder whether that doesn't mean that the UK then must give an indirect credit in spite of what UK law says. Otherwise, this is very, very close to if it is not treaty override, right? But that does not get discussed here. I've got One last point, and that is, who has heard of Memec and what is Memec and why don't we see it anymore? But before we come to what happened to Memec, I just want to talk a bit about the math behind the Memec case, because I'm not sure that I've got it right in the first slide, and there's also some complexity in this, the first slides and earlier in the first video. So let's just talk through this, right? Some food for thought. How many tiers of indirect tax credits was Memec allowed to in the UK? Was it both for Memec GmbH's taxes, or was it also for the subsidiaries taxes? And I'm talking about the very first structure before they had the silent partnership. It seems to me that the original structure implied 2 tiers, right? Because it seemed to me that GmbH, Memec GmbH, paid no further tax in Germany, so it must have been the subsidiaries tax which got credited, right? That's the first one. The second one is, the original structure led to no additional tax in the UK due to the overtaxation in Germany, right? Because of the combination of Gewerbesteuer, which was 20%, plus the Körperschaftssteuer, which was 36% of the rest, plus the German dividend withholding tax, which was 15% of whatever was left, right? So that's why they changed to the structure that you now see on the left-hand side. And the silent partnership structure did, the court tell us, bring the total effective tax to 68%, which is a lot better than the original 43.52% that you can see in the bottom left here. But if you think it through, the silent partnership, what it effectively did was it got rid of the German overtaxation by effectively making Memec GmbH's dividend tax deductible for Memec GmbH through the silent partnership. And this is an interesting thought to entertain, right? Because under BEPS, it was quite clear that one of the things that needed to happen was that dividends that were previously tax exempt are now getting credits. There's a switchover clause in Article 23, so that you can't get the exemption anymore, because the dividend, the income tax that's avoided in the subsidiary country through the deductibility of the dividend then needs to be moved to the shareholder country, where it can be taxed as a creditable dividend as opposed to an exempt dividend, right? So in that way, Memec was way ahead of BEPS BEPS itself, right? And this reduced the total German tax from the 56.48% to 68% as the court have told us, or from 56 to 32% as the court have told us, because 68 was left, and presumably the 32% includes the 15% dividend withholding tax, and then if you gross things back up, you come to approximately 17% in income taxes. And that raises a number of questions. If we assume that the UK tax rate is 34%, because that's what the court told us, then what was the UK tax base that Memec appealed against? Was the tax base the 68? So that if you multiply 68 by 34%, that you end up with 23. So Memec would have to pay on top of the original 32 that was paid already, because remember, it ended up with 68 after 100 of the profits of the subsidiary. It would have to pay another 23, which means that the total tax would have been 32 plus 23 is 55, or 55%, which is quite a lot. Or was the 68, was that grossed up with a 15% dividend withholding tax, bringing it up to 80, right? And do you then have to say that 80 times 34% is 27, and then you can deduct the German dividend withholding tax of 12, so you need to pay another 15, which would have brought the total tax from 32 to 32 plus 15 equals 47%. Or do you have to say that it was grossed up to the full 100? I don't think so, but if it was, and you have to pay the full 34% tax on that, but you can't get any credit whatsoever except for the direct tax credit for the dividend withholding tax, then you would end up with 34 minus 12 equals 22. So then you would have paid 32 in Germany and another 22 in the UK, ending up with 54, which is almost a 55 if you are only taxed on the 68, right? It's not clear because the court doesn't discuss those numbers. It seems to me that what most likely happened was that the income was grossed up to 80. And then the question is that Memec then get the 15% direct tax credit. And I assume if you're going to gross up the income in any case that you would then also give a credit. Otherwise, why would you gross up the income? If you have knowledge of how this calculation actually was done, if we have any other thoughts about how it was done, remember the UK tax system in that time was pretty complex. I believe they also worked with frank dividends at that time already, and it was an importation system. Things were messy, but comments and suggestions are welcome. And the answer is in this somewhat strangely spelled and written article, which is online. You can see where one could find it. And it says, as the Memec name disappears and Premier Farnell is acquired, a distribution veteran steps down. So what was Memec? And it gives a short history. After 40 years, the Memec name has disappeared from the distribution world. The company was established by Dick Skipworth in 1974 and run at first from his home. Memec, which stands for Microelectronics and Memory Company, shot to acclaim by revising the guidelines of how electronic components were derived and sold. Memec as a company was specialized in finding new components for new businesses, overwhelmingly on the US West Coast, and selling them aggressively into Europe. Earlier distribution was more about fulfillment. In such a way, a company was so successful that it went public in 1980. So this company, Memec. And when it went public, the offer was oversubscribed by more than 50 times, right? Skipworth then sold Memec to a German company, Weber, in 1991. And then I guess they didn't do very well with the business because he bought the business back in 2000, probably much lower price than for what he sold it. And then he offered it to Avnet in 2005. And presently, what was Avnet Memec, because they merged the names, has merged into Avnet Silicas Association, with the Memec name being relegated to history, and therefore we now only have Silica left as name. I think it's interesting to also know where these companies come from when we look at these cases. I hope you enjoyed this case. That's it for this week, and I look forward to seeing you next time.